Standing Committee on Health. In accordance with our routine motion, I'm informing the committee that all remote participants have completed the required connection tests in advance of the meeting. Pursuant to an order of reference adopted by the House of Commons on Wednesday, May 29th, 2024, the committee is commencing its clause-by-clause consideration of Bill C-368, an act to amend the Food and Drugs Act, Natural Health Products. I'd like to welcome our witnesses who are available to us as experts for any questions related to the legislation that members might have. They are from the Department of Health, David K. Lee, Chief Regulatory Officer, Health Products and Food Branch, and Kim Goddard, Director General, Health Product Compliance Directorate. We also have a couple of people to my right from the Office of Legislative Counsel, Alexis Labelle and Jean-Francois Labbé, for any procedural questions. I'd like to provide members with some instructions and a few comments on how the committee will proceed with clause by clause of Bill 368. As the name indicates, this is an examination of all the clauses in the order in which they appear in the bill. I will call each clause successively, and each clause is subject to debate and a vote. If there are amendments to the clause in question, I will recognize the member proposing it, who may explain it. The amendment will then be open for debate. When no further members wish to intervene, the amendment will be voted on. Amendments will be considered in the order in which they appear on the bill or in the package each member received from the clerk. Members should note that amendments must be submitted in writing to the clerk of the committee. Amendments have been given a number in the top right corner to indicate which party submitted them. There's no need for a seconder to move an amendment. Once moved, you'll need unanimous consent to withdraw it. During debate on an amendment, members are permitted to move sub-amendments. These sub-amendments must be submitted in writing. They do not require the approval of the mover of the amendment. Only one sub-amendment may be considered at a time, and the sub-amendment cannot be amended. When a sub-amendment is moved to an amendment, it is voted on first. Then another sub-amendment may be moved, or the committee may consider the main amendment and vote on it. Once every clause has been voted on, the committee will vote on the title and the bill itself, and in order to reprint the bill may be required if amendments are adopted, so that the House has a proper copy for use at report stage. Finally, the committee will have to order the chair to report the bill to the House. That report contains only the text of any adopted amendments as well as an indication of any deleted clauses. All right. Dr. Ellis.
Thanks very much, Chair. You know, I think that we adjourned debate last time on a very important motion related to this bill, which specifically respects the data that has been egregiously reported here in this committee with absolutely any evidence. And, you know, certainly as we begin to look at that, I think that we need to return even to the original omnibus bill in which the changes that originally occurred, transforming natural health products to therapeutic products, which was done, of course, in as I said, in an omnibus bill, which attempted to hide that, I think, to the public. That being said, during that original time that we heard from witnesses from Health Canada, and we specifically heard from Dr. Supriya Sharma, we know once again that data was referred to which has never been substantiated. And the sad fact of the matter is that simply because the obfuscation of witnesses who were here this time, they absolutely refused to provide that data. And the sad part of it is, in spite of many disagreements we've had at this committee, we have had the ability to have documents tabled here, which has been a regular occurrence, thankfully. And it's something that we've agreed to. Sadly, that couldn't occur at this time. And subsequently, I moved a motion for ISMP to provide the dates of occurrences, the specific substances that were in question, the outcomes, etc. And it's interesting, I had the opportunity to review the footage from that meeting, and I asked representatives from that group 3 times to come forward and provide data to substantiate their claims. And each time they talked about privacy, they talked about, it was very unclear what their point was. My point, though, is very clear. If you want to come and make claims about an industry that is a $13 billion industry that is mainly comprised of small and medium-sized businesses here in Canada, that is an incredibly important, often a family business, often run by women, then you need to substantiate your claims. And that is something that is absolutely egregious not to be held account by our Liberal and NDP counterparts who adjourned debate on this particular motion at the last meeting. So, you know, on behalf of those entrepreneurs who really want to be able to continue to ply their business in our country, shame on the Liberals and shame on the NDP for adjourning debate. We could have settled this already, but once again, for reasons unbeknownst to me, perhaps it is the return of the marriage of the NDP and Liberal leaders, despite the much touted public tearing up of the agreement. Clearly, everybody knows that the renewal of vows has reoccurred. So as we begin to look at that,
Point of order from Mr. Julian.
I'm certainly questioning relevance because Dr. Ellis is off on a tangent, but I'm also a little bit perplexed. This is really important legislation. I'm glad that Mr. Calkins is here with us today, and we have important amendments to consider on the bill. Perhaps Dr. Ellis could share with us why he's filibustering this bill.
Dr. Ellis is talking about things that were relevant to the bill, and I expect at some point he's either going to introduce a motion either to resume debate or a brand new motion along the same lines. That's what I'm waiting for. But he's on a topic that will lead to that. We'll see where it goes. Do you have a point of order as well, Mr. Thériault?
Oui, Monsieur le Président.
Yes, Mr. Chair. I believe, if I understand correctly, that Mr. Ellis is trying to provide a preamble to the work we're about to do. I would agree with allowing each party to provide a preamble, an opening statement, if you will, before we get into our work here. I mean, I would, a preamble also to provide before we get into the study. We heard a lot of things from his part, and I want to really look at the framework for the amendments before we get into the amendments. So if people agree, we could provide a certain amount of time, and I don't need more than 2 minutes personally, 2.5 minutes to provide my own preamble or statement. So that's what I wanted to say. Perhaps Mr. Ellis could conclude his preamble.
Moi, j'ai une...
I have a document indicating the process we're going to follow, but if anyone raises their hand, I must recognize them, and if they have something pertaining to the study, if it's relevant, they have a right to raise it, as was shown by Dr. Ellis. So I'd like to add my name to the speaking list then. Ms. Goodrich, you're next, and then you.
thank you very much, Chair. You know, in spite of efforts, again, to silence this very important topic of data production in the face of, again, egregious and unsubstantiated claims directed towards the natural health product community, I think it important that we really need to set the stage so that folks who are out there listening, and again, I want to bring people back to the fact that I know that every member of this committee, including Dr. Pawlowski, Dr. Hanley, Perhaps not Mr. Nackby because he wasn't there. I know Ms. Sidhu has been here throughout this this entire disgraceful episode. But we received more correspondence on this particular issue with respect to natural health products than any other issue that has ever come before the Health Committee in the 3 years that I've been here. Everybody, and I know that we've brought them to committee before, stacks upon stacks upon stacks of people reaching out and saying, do not take away my access to natural health products. And once again, what we have heard from witnesses who have appeared here, again, I'll refer back to the original omnibus bill when officials from Health Canada said here very clearly, you can search the database for yourself. So when we asked that, and this is why, Chair, this is particularly important. When we asked them where the numbers came up and what the particular adverse effects were, they said, you can search the database for yourself. Would you table the actual adverse effects in writing with the committee? And the answer we got back was the exact same answer, which is disgraceful, which is exactly why I think it important to have this motion acted upon and the data brought forward on behalf of families and entrepreneurs who have natural health products and businesses for natural health products, which is a $13 billion business in Canada. So when we asked Health Canada officials that question, they said, oh, go look at the database yourself. When we said table that with the committee, the exact same answer came up. Go and look at the database yourself. And I don't know how many people around the table here tried to look at the database. We spent hours attempting to look at that database, which we should never have to do, but to substantiate the claim of Health Canada with respect to natural health products.
Excuse me, Dr. Ellis, I'm sorry. Somebody has a cell phone that's close enough to the microphone and is vibrating, and we just got an indication that it's probably not good for the interpreters. So, okay, go ahead, Dr. Ellis. Sorry for the interruption.
No, that's okay. So again, we spent hours of our own time in our own office looking at this database and trying to substantiate the ridiculous claims of the Health Canada officials, which again, because of the nature of the database, it is impossible to do. That was the first instance to say that moving a motion to compel purporters of claim to actually table that information, why it's so important and why that motion was very, very specific in what it had asked for. Then the second instance we had, and I know I've mentioned this before, but I think it's important to try to put this all in one package, Dr. Supriya Sharma, who was here at the same time with the original omnibus bill, who claimed, sadly, that a child who died in Alberta, it was the result of natural health products. And that was very clear that the result, that it pains me to bring this up again, but it's such an egregious and untrue claim that it bears repeating because the child died, if I'm not mistaken, of viral meningitis. And for a physician to be here as a representative of the government working with Health Canada, I think that is shameful to say that that child died due to natural health products when that is absolutely untrue. I was going to call it a lie, but I'm not going to call it a lie. I'm just going to say that it's absolutely untrue. And that's absolutely shameful. And so then we came back because our great friend who happens to be here at the table today realized that the classification of natural health product as therapeutic products is what allows the cascade of ridiculous events, meaning that therapeutic products will then be required to have significant labeling changes with tiny font, increased use of plastics, labels that are going to fall off because they're going to be so huge, that then the cost recovery program can also be enacted, much contrary to the comments of Minister Holland, who said that the change in definition wouldn't change all of those things, but it is the change in definition which allows all of those things to happen. So then we also heard, of course, representatives from the anti-smoking and anti-nicotine group who were here, who suggest that nicotine should not be part of the natural health products regime, and that they wanted to specifically fight the bill based on that. And then, so then when you begin to look at that, you know, there's easy ways to make these things happen in terms of removing nicotine-containing products from the natural health product legislation. The other group, of course, I mentioned already, ISMP, who were here, who mentioned 700 claims of, since 2019, of side effects related to natural health products. Now, they were, again, very unclear in what they presented. One of the claims, if I remember correctly, and again, I looked at the footage, was that somebody read the label wrong, got the wrong product, and was upset because they couldn't get a refund. Now, I don't think that that is a side effect from a natural health product. I think that's a side effect from not reading properly. But that's my own opinion. All the way to their egregious claims of multiple deaths. Now, again, why is this important? It is important because people should not be able to come here and make egregious claims without data to support what they are saying. We even had a physician from Sick Kids who was here saying that multiple children died because of natural health products, but once again refused to provide any cases. I asked that physician specifically, how many children were there? What did they die from? What was the toxic substance, et cetera, and there was no answer provided. So it is this comedy of events, they're not even errors, and it's certainly not funny that people come here and make egregious claims against the natural health product industry, and nobody here, besides the Conservatives and the Bloc, want to hold them to account. The NDP Liberal Coalition wants to adjourn debate on this specific motion,
Point
and
of order.
clearly that they do not want to have this
Point of
information
order from
before
Mr.
committee.
Julian.
Again, Mr. Chair, I want to cite relevance and repetition, and I'm kind of flabbergasted. This is a bill that the NDP supports, that Mr. Calkins has presented. We have important amendments to consider, and it's being filibustered by the Conservative health critic. I just don't understand at all the objective, but he is repeating himself, and he's not relevant to the debate. And I would ask you, Mr. Chair, has he actually moved a motion, or is he just speaking?
He hasn't moved a motion. He is just speaking, but he is speaking to the bill. It's hard to say that it's not relevant. I'm sorry, Mr. Julian. Go ahead, Dr. Ellis.
Well, thanks very much, Chair. You know, and again, I want to point, I think this is worthwhile pointing out, and I know it's painful to Mr. Julian, but the sad part is that Mr. Julian was that we knew that the Liberals were going to vote against this because, of course, they moved the original bill to gut the natural health product industry. And I think it's shameful for Mr. Julian to have been the one to adjourn debate on bringing forward data that is specifically related to this bill and to the natural health products industry, from which he claims that he's a huge supporter. Now, not to mention the fact that one of his amendments that he has brought forward is basically a wrecking amendment towards Bill 368. And as you begin to consider his amendment, I think that we'll find that we'll ask you, of course, Chair, to rule against the admissibility of his ridiculous amendment as we go forward. So with that, I think it incredibly important that we resume debate with respect to the data that we have requested at the last meeting related to the natural health product industry, because it provides important context for Canadians to understand that by and large, this is an industry which is safe, which is effective, which is proudly Canadian, which, if the NDP Liberals are allowed to have their way, will wreck the industry, will drive businesses out of Canada, and force Canadians to purchase products online, which, again, will never be tested up to Canadian standards because there's no law requiring them to. They will be able to access products from any jurisdiction which they wish. And we have an opportunity specifically to ensure an industry which we've heard multiple testimonies related to the safety and the interest of those involved in the industry, of how safe and they're willing and open to have changes We've talked to them that they're willing and open to have changes with respect to removing nicotine containing products from natural health products. And we also know that the concept of recall, and I know that our colleague from the block has submitted specifically an amendment with respect to recall that we certainly would support, which makes perfect sense. We heard clearly that inside the industry that moving amendments related to those two things would make perfect sense. So, very specifically, Chair, with those things in mind, I move that we resume debate on the motion I proposed at last committee meeting, which was adjourned by the NDPs and Liberals, to demand that ISNP bring forward data that they cited at that last meeting as well with respect to natural health products. Thank you.
A motion to resume debate is a dilatory motion that is not debatable, so we will go straight to a vote. But just for clarity, the motion that Dr. Ellis moved at the last meeting, which is the subject of the motion to resume, reads as follows: that the Institute for Safe Medication Practices Canada provide the list of 700 incident adverse reactions, the date of incident, product, and outcome to the Standing Committee on Health within 30 days. So the question for the committee is, shall the debate on that motion resume? All those in favor?
Chair, I'd like to request a recorded division, please.
Madam Clerk, a recorded division has been requested.
Mr. Henley,
No.
Madame Kayabaga,
No.
Mr. Nakvi,
No.
Mr. Polowski,
No.
Madame Sidou,
No.
Mr. Ellis,
Yes.
Mr. Majumdar,
Yes.
Mrs. Goodrich,
Yes.
Mr. Calkins,
Yes.
Monsieur Thériault,
No.
Mr. Julian.
No.
Yeas 4, nays 7.
So the motion is defeated. At the time the motion was moved, I had Ms. Goodridge and Mr. Thériault on the speaker's list. Do you still wish to have the floor, or was it on that? Okay, well, Ms. Goodridge and then Mr. Thériault, please.
Monsieur le Président, c'est une question de...
Mr. Chair, it's a question for clarification. Okay. It's not because we're not resuming the debate regarding tabling documents at the committee within 30 days. Actually, we'll have adopted and looked at the bill. I want those documents to be tabled, but I think we can ask the organization to table the document without having a whole debate over it. I hope everyone will agree to that request, to the committee making that request. And since the study will have been concluded, well, we'll be able to refer to that document later. It could be interesting for further work. So that's my motion. I wish that through unanimous consent, we agree to that, and that it shouldn't need to be a motion for it to be done. Mr. Thériault, I believe you went a bit further than a point of clarification, and you tabled a motion or proposed a motion and asked for unanimous consent. I would ask you to redo it when you have your speaking turn after Ms. Goodrich. And Mr. Julian, do you have a point of order, or do you want to be on the list? I'd like to be put on the speaking list. Ms. Goodrich, please.
Thank you, Mr. Chair. So one interesting piece, we get lots of correspondence and we've asked for lots of facts on this and we've had lots of information being shared from both Health Canada officials, the Institute for Safe Medication Practices Canada, and I found it really interesting. We got a letter very quickly back from the Institute for Safe Medication Practices Canada in both languages that went into our HESA email stating that they would happily provide the data, but only within 2 weeks and only after we made a decision. So basically, even though I asked specifically in the meeting if they would provide the information, they said yes, and then have decided that they're only going to provide this information if we actually vote on it, which I think is fairly telling, and that they're setting the timeline as to how long they will give it, and they dictated which information they would give us. Not that parliamentarians get to decide which information, but they've set out what they will actually allow. But one other concern I actually really do have. So when we had the Minister of Health here, they spoke of all of the different adverse impacts, and the minister talked at length about feces and a variety of issues, and made it sound like perhaps this entire industry had some very serious issues when it came to feces. And then in doing some further clarifications, we asked for information as to like how many of these incidents. Eventually, we found out that there were 3. So we asked for them to table this with the committee. Health Canada tabled information with the committee, but they only tabled information with the committee in regards to the one feces case. So we still don't know the other 2 cases. We still don't have that information. And so this is another space of us not having the information that we have requested, that we as a committee need to have in order to move forward with this. And so it's very frustrating that this government, this Liberal government, is trying to destroy a $13 billion industry. And they have all these safety concerns that they've brought up. But when push comes to shove and we ask for the data, they cherry pick which data they actually provide to us. And Canadian small business owners that are primarily female small business owners are going to be the ones suffering the consequences of the fact that us parliamentarians don't actually have the right information. And I don't understand. This wasn't that difficult. We didn't ask for that much information from Health Canada, and we didn't get 2/3 of what we asked for. Like 3 incidents, it should not be that difficult. And they said there was noted 282 observations regarding unsanitary conditions. They didn't give any details in regards to what those looked like. They didn't give any of the details. They literally gave us sentences that had data sprinkled in and not actual information. And so I'm just raising this because this isn't the quality of information I would expect to have at the committee. And the letter that came from Ms. Hoffman with the Institute on Safety of Medication, that's not okay. That's not what we should be getting from a witness of like, here's the information we will provide to you. Last time I checked, Parliament has some pretty wide-sweeping rules that we can ask witnesses for a variety of information. And if you're going to come in here and share information with us, you should be willing to actually share all of the information with us should we request it. You don't get to tell us which information you will and won't share. That's not how parliamentary privilege works. Thank you, Mr. Chair.
Thank you. Mr. Thériault, s'il vous plaît.
Mr. Thériault, please. Thank you, Mr. Chair. So all I wanted to say was that it's not because I voted against the motion earlier to obtain supplementary or additional documents that I voted against, really, but it's just that I don't think we need to hold this debate, and we don't need this information in order to be able to do the work we have for today, and I'll explain why. First, we tabled 3 amendments to Bill C-368. And in 9 years, maybe I don't have enough experience here, but I've never worked so hard for 3 amendments because we had to work on C-47, other bills, and the Vanessa bill also, And the elephant in the room that nobody's talking about here, Mr. Chair, is the rules on the natural health product regulations, rather, that we find everywhere in this bill and our amendments also. These are key elements for the protection of consumers. They already exist. We have them. And you'll see, I really worked on this. I worked hard, and this is the key element. If we had to rewrite everything today, these regulations for natural health products or natural or therapeutic products and so on, I would say, yes, of course, I'll wait 30 days to have these documents. But, Mr. Chair, and this is my preamble, it's important to understand the public's concerns regarding this bill. That is, from the organizations that came to see us and the ministers also. There are 6 key ones. I'll summarize them. We were told that nicotine-based products are extremely dangerous. They need to remain in Vanessa's law, and what we saw in August also from the minister and the department. The minister must retain the ministerial power, rather, to recall for natural health products, and intoxication based on that are dangerous. We know that. We also have to do post-marketing studies. We know that also. That's also in the regulations, in the natural health product regulations. 6, new products such as new drugs, which this was raised by the minister. If C-368 passes, there will be problems with precursors. Nicotine products are very dangerous. They need to remain in the law. That's very important, Mr. Chair. That's why we have an amendment that would leave the nicotine products in Vanessa's law and elsewhere. 2, the minister must retain the power to recall in case of dangerous products for pharmaceuticals and also other products. 3, the minister must retain the ability to require changes to packaging and labeling. Now, that's in case of risks to health. The minister can impose a change in labeling without Vanessa's law being applied simply by using the natural health product regulations in section 16 and 17 of the regulations, page 13 in the French. Now, under what's currently there, Health Canada is allowed to require that a business change its labeling, including providing new warnings if the department has reasonable grounds to believe that a product is no longer deemed to be safe when used as recommended or not used as recommended. Health Canada recently used that same authority to require new warnings on certain products. There are options. You can show that the warning is not sufficient, or there are other ways to do it, and it has been exercised recently. 4, now talking about overdoses. So it's not necessarily relevant here. There are 2 things. The regulations need to be applied properly, and Health Canada needs to look at dosage indications and other requirements on the labels, and they have to be applied properly. And that is the duty. It's not an authority and duty that is imposed by Vanessa's law. The department and the minister already have this authority, and that's what we heard, and that's what led to C-47. 2, Health Canada absolutely needs to do its duty, which is to provide information on health to help Canadians and Quebecers make decisions, informed decisions. Health Canada has to provide an education campaign regarding health products and medication and their interactions, and also indicating how important it is to follow dosage information the same way it did for medications. The department provided information campaigns regarding dosage and medications. The same thing needs to be done here. It has not yet been done. Health Canada needs to be able to do that and is able to do that. It is not through Vanessa's law. It is part of Health Canada's duties. The problem is that for several years now, over the past several years, Health Canada has not exercised its powers enough, even though it legitimately had the right to exercise these powers. And so that's what the Auditor General was denouncing. 5, we have to have the ability to inspect products and to conduct post-marketing monitoring. That's not included in Vanessa's law. It's included in the regulations. You'll see it in 17.1 on page 13 in the French version. Section 16 covers pre-commercialization, and Section 17 covers post-marketing. And we'll see in Section 17.1, 17.1a, on page 14 in the French of the regulations, the minister can order distributors, importers, and providers to stop selling certain health products in the following cases. And there's a whole list. For example, they're not in line with Section 16 of providing information within the prescribed timeframes, or the information provided under Section 16 are not sufficient to show that the product is safe when used according to the recommended usage. C, that there are, the interpreter notes that she does not have the regulations, and there are also good production and packaging practices. That's on page 24 of the French, and we can see the equivalent. And that's in cases of imported products. I'm almost done, Mr. Chair. D, there are reasonable grounds to believe that a product has not been manufactured or has not been provided or marketed in accordance with Part 3, good production practices, in the case of a product that is not imported. 1, there are reasonable grounds to believe that the product has not been labeled or packaged in a way that is compliant with what we see on page 5 of the regulations. New products, for example, new products that are dangerous, that may be dangerous. I mean, what is happening with those? We talked about them briefly, but I want to discuss it here because we really care about the health and safety of Canadians and Quebecers. The precursors are covered by Section 1 of the Act regulating the certain substances regarding the transport, production, and other of certain designated substances. So regarding precursors, there are already offenses and punishments that have already been set out in the regulations and elsewhere, and that's also for precursors and also chemical products. These are substances that are used to make illicit substances. Most of these also have legitimate commercial purposes and are used in a legal context in a variety of industrial processes for producing products such as perfumes, medication, and others. So we could be adding those substances. Mr. Chair, I hope that I was able to show that we cannot simply make amendments to 368 that do what? That simply state that we can't leave out in the environment, the legislative environment, regarding natural health products and Vanessa's law, certain things. We need to remove them from that context and to bring the amendments we need to see in line with the natural health product regulations that will cover the concerns consumers have. And then we'll see that recalls won't be simply if people feel like doing it. They will be mandatory. The minister and the department will have the authority to require for that to be done, and it will not be up to businesses. By making sure that we put in place the amendments that I can explain further later while we study them, I think we would have the tools to go ahead. We have the documents here that we need to do the work we need to do this afternoon. Thank you.
Mr. Julian, please.
Merci beaucoup, Monsieur le Président. Et
Thank you very much, Mr. Chair. I will continue in the same vein as Mr. Thériault earlier regarding the Institute for Safe Medication Practices Canada. I will table the earlier motion, hoping that it will be unanimously agreed to. I do not wish to filibuster. That's not what I was trying to do Tuesday either. But I find it important for us to have this information. As a committee, as a health committee, we need to be able to receive the information we need. That's important. We have a responsibility with this regard.
to this bill is to start by thanking Mr. Calkins, who I often have differences with, but who I think has done Canadians a real service by presenting this bill that we voted for on second reading to bring to committee. And I will say this, and I hope not to embarrass him, but it was one of the strongest presentations I've seen by a member of Parliament defending his or her bill before this committee. I thought he was very well prepared and very effective in answering the questions. So we take the bill very seriously. We'll be going into clause by clause shortly. I believe that all of the witnesses that have appeared have done a very effective job of presenting the importance of the bill and some areas where it could be improved. And of course, this is always our responsibility as legislators, Mr. Chair, to take a good bill and to make it better. And in this case, because we're talking about an industry that has so much importance across the country, that helps and provides for the health of Canadians. And as I've mentioned, and that Mr. Calkins has as well, we're consumers of the products, the natural health products. They're a way of getting us in better health. So it is important that we take this bill very, very seriously. I know all members have. And so I have been reviewing the transcripts, reviewing the witnesses, and it is very clear to me that the industry has the highest possible standards, does an effective job of meeting its obligations to Canadians. But I am also aware that there are some bad apples, and we've seen just in a handful of cases, companies that haven't reacted effectively to voluntary recalls. And so the amendment, the two amendments that I'll be offering today for the committee to consider is to retain, of course, the ability to have a mandatory recall in those rare cases. It's an extremely effective industry, high safety standards, and the best way to maintain that is to ensure that that occasional bad apple can be dealt with appropriately. And also to address the issue of penalties that are incredibly high and absolutely disjointed and irresponsible, given the importance of the natural health product sector and the fact that many of them are small businesses. And so those are the amendments that I will be offering today. When we get to consideration, I note that we've lost the first hour already of our committee, so we only have a little over 45 minutes left. I hope that we can get to clause by clause. We don't have a lot of amendments, but I'm sure that our witnesses will be receiving a lot of questions. And I did want to thank Mr. Calkins for bringing this bill forward and in doing it in such an effective way. The bill will pass either today or when we do consider it, not without, I believe, some improvements, but there is no doubt that the leadership he has shown on this bill will mean that ultimately the bill will be adopted by this committee. I certainly hope that is the case, Mr. Chair. So I'm going to raise, as I mentioned earlier, by unanimous consent, the following motion, hoping that we can just adopt it rather than spending any more time on a filibuster. That the Institute for Safe Medication Practices Canada provide the list of 700 incident adverse reactions, the date of incident, product, and outcome to the Standing Committee on Health within 30 days.
Is there unanimous consent to adopt the motion? Dr. Ellis.
Sorry, Chair, could you read that again, please, Mr. Julian?
In their letter.
Thank you, Mr. Chair. The motion that I read has within 30 days, so that the Institute for Safe Medication Practices Canada provide the list of 700 incident adverse reactions, the date of incident, product, and outcome to the Standing Committee on Health within 30 days. That was his motion.
Is it the will of the committee to adopt the motion as presented by Mr. Julian? Dr. Ellis.
Thanks very much, Chair. You know, a friendly amendment, if we could change that to 2 weeks, I think that that would be acceptable to the Conservatives.
Dr. Pelosi.
Just a question. I'm not sure how this differs from the original motion we just voted down.
The difference is the committee can do anything it wants by unanimous consent. So as long as everybody agrees, it's a non-debatable unanimous consent motion. So I guess so that's where we are. Dr. Pelosi.
If I still have the floor, I think this doesn't address the concern that they had, which was in disclosing.
It's not debatable. It's a yes or a no.
Okay, then the answer is no. Not you.
Do we have unanimous consent to change the last two words of the motion, or the timeline on the motion from 30 days to 2 weeks? Is that
Mr. Chair? I'll just reread it.
Yep.
At the Institute for Safe Medication Practices Canada, provide the list of 700 incident adverse reactions, the date of incident, product, and outcome to the Standing Committee on Health within 2 weeks.
Okay. So you've heard the motion. Is it the will of the committee to adopt the motion as presented? Yes. The motion is adopted. There's nobody else on the speakers list. The chair calls clause 1. There is one amendment to clause, the first amendment to clause 1 is...
Sean, I had my hand up.
Oh, Dr. Pelosi, you did indeed. Yes, sorry, go ahead.
So just before we start going clause by clause, I did want to say something. And I see that Luke has done a lot of work on this. I think also the NDP have done a lot of work in amending this. I really have to compliment both of them for having spent the time to try to figure out how to make this work, given the competing concerns. I think, as we will see, that I shall be in favor of the NDP amendments rather than his. However, I did want to say to Luke that perhaps his would have worked as well, but the NDP amendments seem to me much simpler and easier to do than to go through all his things. But I'm certainly impressed by the fact that Luke went through all the regulations and found out which regulations would apply irrespective of the act. And I do want to thank Luke for all his hard work. And he may well be right that what he proposes would have been just as good. But I wanted to throw that in because I think Luke's done a great amount of work. And as always, he's done a great job.
Thank you, Dr. Pelosi. After such comprehensive opening statements, I think the only thing left to do is probably to vote, but perhaps I'll be proven wrong. So I have called Clause 1. The first amendment to Clause 1 is NDP 1. Do you wish to move and speak to that, Mr. Julian?
Thank you very much, Mr. Chair. And again, my thanks to Mr. Calkins for bringing this forward. This is really important legislation. And so, as I mentioned in my preamble that you graciously gave to me, Mr. Chair, I understand the concerns that have been raised by the natural health products sector about all the additional powers that have been given to the minister. And so the NDP 1 would amend the bill by replacing line 8 on page 1 with the following. Quote, combination of drugs and devices, but for the purposes of section 21.31, 21.32, 21.33, 21.7, and 21.71 does not include, and then it continues on, a natural health product within the meaning of the natural health products regulations. The intent here is to take away many of the other powers that have been given under Vanessa's law and that the sector has raised very legitimate concerns about. But you'll be sure to point out, Mr. Chair, it continues to allow the minister to recall a product and take it off the shelves. Now, this is something that I think from the evidence that we've heard, and we've had very effective witnesses coming forward. There are very occasionally in this sector companies that for whatever reason will not respond to voluntary recalls. So I do understand the importance of ensuring that when there's a risk of injury to health, that there is the ability to force a mandatory recall in those rare circumstances. And so that is why I'm presenting this amendment to ensure that the mandatory recall provisions are maintained and those other powers are taken away. I wish the government would have consulted the sector, the industry, before the Vanessa's law was put into effect, but I think this helps to mitigate most of the concerns that they have raised while maintaining that requirement or that ability of Health Canada to ensure a mandatory recall in rare circumstances where the company has not been cooperative.
Dr. Ellis?
Thanks very much, Chair. And, you know, certainly I have a difference of opinion with respect to Mr. Julian. I think, and I suspect we'll need a ruling from you on this, Chair. The thing I will agree with Mr. Julian is that during the testimony we heard about the powers of recall and the importance thereof, I'll also agree with him. I know this, you'll find this shocking, but I'll agree with him again that is something that within the industry we heard great acceptance thereof. That what I'd like to point out to you, though, Chair, with respect to admissibility is that in essence, Bill 368 changes the definition of a therapeutic product, meaning that a natural health product is not considered a therapeutic product by the overall scope of this bill. And then when you look at the Food and Drug Act cited in Mr. Julian's amendment, it goes on to say that, and to talk about a therapeutic product. So in my mind, those two things are diametrically opposed. It becomes very difficult to exclude natural health products from being a therapeutic product, but then cite regulations inside the Food and Drug Act, which then call it a therapeutic product. That is, in my mind, as I said, it's a binary decision. You can't be and not be a therapeutic product at the same time. So that would be the difficulty that I would have, and I would go on to suggest that there perhaps are again, directly contradicting Dr. Pawlowski, but there are proposed by Mr. Theriault more elegant ways to allow the minister to have those abilities of recall, et cetera, that we talked about. And I think in essence, when you look at the amendments would specifically come back to two things: the ability to recall products, which again, we variably heard that already exists, but again, strengthening that ability. I don't think there's going to be any argument against that. And the second part of it, of course, is the removal of nicotine-containing products from the definition of natural health products. The concern that I would have, and I think when we begin to muddy the waters of the definition of a therapeutic product, allowing it to be a therapeutic product in one sense but not in another, that is going to create significant difficulties with the original omnibus bill that was presented by the NDP Liberal government back in the spring. as the definition of a therapeutic product, of a natural health product becoming, in essence, a therapeutic product, then would allow all of the other changes which come about thereafter, meaning the cost recovery program and the labeling changes as well. So as we begin to look at this, as I said, in my mind, those two things are diametrically opposed. And again, when you look at admissibility rules, given the fact that the principle of the bill is to move natural health products out of the therapeutic product realm, the admissibility rules would state that the most common rules of admissibility are related to the principle of the bill, and the principle of the bill is the object or purpose which the bill seeks to achieve. The principle of the bill is fixed when the bill is adopted at second reading. Any amendment contrary to the principle of the bill is inadmissible. And so I would suggest, and again, I think that if the actual principle of the bill is unclear, we have a unique situation here that if it's unclear in writing, we could actually ask the drafter of said bill what the principle of the bill, and I think that would be very clear that moving all natural health products away from the definition of a therapeutic product is really the principle of this bill, and therefore that makes NDP 1 inadmissible as an amendment. I'll say it one more time. That doesn't mean that we don't support that type of movement. Just the NDP 1 amendment has to be deemed inadmissible by yourself. So thank you, Chair.
Okay, thank you, Dr. Ellis. We have Mr. Thériault next.
Oui. Ben,
Well, I think that reading through this, I mean, it's pretty clear what it's saying. And I think it's correct. I was listening to Mr. Julian's reasons for proposing this, and I felt like it wasn't exactly what the modification or the amendment was trying to do. What they're doing is leaving natural health products in there, but taking away the exception, leaving some in the therapeutic products, but saying, for example, we'll remove obligations 231, 232, 30, and others. But that's like saying, well, the bill indicates certain things, leave the exceptions, change the environment, not have what's covered under Vanessa's law. But by removing those sections, well, that would mean that they don't apply. But they're already in the regulations. They're already there. So it does nothing really. It just goes against what the bill is trying to achieve. That's how I see it. And maybe the clerks or the analysts have something to say, but that's why I thought my BQ2 would be related to that, and that it would be related to NDP 1, because in BQ2, I'll explain it later, but we go back to what the minister can do, whereas in the NDP's amendment, that authority is already there in C47. So there's a problem here. In the intent, perhaps, in Mr. Julian's intent, perhaps, but it seems to me that BQ2 is better suited to what the bill is trying to achieve while ensuring that the minister retains that recall authority. But I don't want to talk about two different amendments at the same time, but it's clear that mine went ahead to do two things. Perhaps I should have provided 4 instead of 3, because BQ2 is really providing a reestablishment of the minister's ability, or authority rather, to recall, which was removed by the bill. And that authority also needs to lead to penalties. That's why we introduced that in 2, because there was a change made, and then in the third amendment, we specify what that is. So I would vote against this amendment because it does not, or really it is not in line with the very point of the bill.
Mr. Calkins.
J'aurais pu penser que c'est un...
I would have thought that it was a government amendment. I thought it was a government amendment when I saw it. If I had been the government and I wanted to put forward an amendment, that's what I would have done.
Mr. Calkins, please.
Thank you, Chair. Despite the flattering comments from my colleague, Mr. Julian, and I'm not going to presuppose his intentions, I will take him at his word, but my interpretation of what would happen if this amendment were to be passed by this committee, it would basically undermine the intent of the bill, which Mr. Ellis has invited me to pronounce again, which is to remove natural health products from the therapeutic product definition. And if you take a look at the list of clauses that this amendment would leave in place for the natural health product industry, it refers numerous times, those clauses that would be exempted, refers numerous times to natural health products being considered therapeutic products, which I believe does violate the rules of admissibility, Chair, but I'll await your decision on that. But for those who would be listening to the debate here at the committee, this would leave in question in the legislation whether or not natural health products could be interpreted as therapeutic products or not as therapeutic products, where the intention is to be very clear that notwithstanding the subsequent amendments that I hope that we can get to, it's been made very clear to me that this would add confusion, uncertainty, and would allow, I think, various interpretations of the law to allow Health Canada to continue on in contravention of what I think the will and the intention of the original drafting of the bill has. So I would recommend, Chair, I would hope that you would see that this should be inadmissible. And if you do see fit, I would urge colleagues at the table to vote this amendment down. And then the subsequent amendments, I think, all address the concerns that were raised by various industry stakeholders and affected Canadians without undermining the intention of the bill that I drafted and had passed at second reading and is here at this committee. So I hope that's helpful and adds clarity, Mr. Chair.
Thank you. That exhausts the speakers list. To respond to the matter raised by Dr. Ellis and Mr. Calkins, by not ruling the amendment out of order, I therefore consider it to be in order. That decision was based on advice that I received from Legislative Counsel. I'm going to ask them to provide to you the reasoning they gave me, which I relied upon in order to rule it in order. If after hearing their reasoning you feel that I've made the wrong decision to declare it in order, it's open to you to challenge the chair, but there really isn't another way to deal with it. So if you could, I'd ask council to explain the reasons why this is in order, and then I'll leave it to you if you have a motion.
Thank you, Mr. Chair. So procedurally, just regarding the procedural aspect, we advised the chair that it was admissible due to the fact that we judged it to be within the scope of the bill rather than contradicting the bill. So basically, we judged that it just narrowed its scope within, rather than being out of scope, for example. That's the advice that we provided.
And for those reasons, I determined that the amendment was in order, and so I see Ms. Goodridge and Dr. Ellis.
Thank you, Mr. Chair. I think it's pretty clear, and I in my understanding, as I read through this bill and then had to go back into the different pieces of legislation to really truly understand what exactly this amendment would mean, that Monsieur Theriault explained in great detail how much work he put in doing this, and I think many members of Parliament put in that same amount of work, perhaps not to the same degree of precision, and I think we need to commend Monsieur Theriault for the wonderful work that he does do on ensuring that Canada does have the best possible legislation. But I don't understand, after the conversations that we've had around this table, and specifically the clarification given by Mr. Calkins, as to how this amendment would be within order based on the very clear admissibility rules of amendments. And so I'm at a loss. The decision was made prior to hearing all of this, and there is no space of changing it. And I don't think it very clearly does not fit in line with the principle of the bill. It very clearly does not fit within the scope of the bill from the person that drafted the bill, who, not in most circumstances, we don't have the luxury to hear from the person that created the bill as to what their intentions were, and to really understand whether something is or is not within scope. We have that opportunity here today. We had that opportunity today. We very clearly heard, and I think that it's exceptionally clear. And so, I'm very frustrated by the fact that the NDP come in here saying that they fully support this bill and they want to get this through, and then they put forward a space where they bring forward a bill that effectively does it in a slightly less direct way than what we had before. So yeah, cool. Maybe this is like a tiny slight bit less bad than what the sledgehammer that came from the Minister of Health and his solution was, but it still does not address the actual issues. And it is not in line with the principle of the bill. It is not in line with the scope of the bill. I don't believe that it has that space. And so this is a space, Mr. Chair, that I truly believe the decision from the legislative clerks are wrong. And I am wondering if what other opportunities, other than challenging the ruling of the chair, what other recourse do we have here? Because I do think that we need to clarify this.
The answer to your question would be none. That's the only option you have. A ruling has been issued, and if the committee decides to overturn the ruling of the chair, then so be it. But there's no other option. Dr. Ellis, Mr. Theriault, and Mr. Calkins.
Well, thanks very much, Chair. And, certainly as we begin to look at this, the sad part is hearing what you've just said, given the fact that Mr. Julian is quite prepared to gut a $13 billion industry, which he so wrongly says he supports, because we know, as I said previously, that the Bill 368 will remove labeling changes, it will remove cost recovery, and will remove many other burdensome legislative policy with respect to the Food and Drug Act as it respects to natural health products. So as we begin to look at that, Mr. Julian himself referred back to how things happened in the House of Commons, and as all of us are able to do, you can go back, you can look at it. Who agreed to send this here to this committee? Yeas 171, nays 146. And as we begin to look at that, clearly there was the will of the House at that time to accept the fact that Bill 368 undid the negative changes that the omnibus bill put forward by the NDP Liberal coalition. And I think the difficulty that exists today is we hear the NDPs wanting to say that they support this industry because they know that they need those voters to agree with them when they introduce a wrecking motion, a wrecking amendment to the actual spirit of Bill 368. And I think it's important that we attempt to put this in context for Canadians, that what we have heard, and let's be honest, this amendment, NDP 1, will return the landscape of natural health products back to where we were before Bill C-368 existed. And when Bill 368 didn't exist, what we heard very, very clearly from every representative of the natural health product industry that came forward, what we heard was, you are going to ruin our business, you are going to put us out of business, you are going to drive our business to the United States, you are going to drive Canadians to buying products online from sources which have absolutely no testing of their facilities, no ability to recall, no need to be careful with the ingredients that are on the list, and no safety requirements. And so as we begin to understand that that is the case that existed after the deadly bill proposed and sadly passed in the House of Commons by the NDP Liberal coalition, that now we know that that marriage of the woke NDP Liberal leaders is back in full force. We heard it today in the House of Commons with their tricky
Point of
tax
order,
street.
Mr. Speaker.
And we
Mr.
know
Chair.
very...
From Mr. Julian.
Yeah, again, I have to challenge Dr. Ellis on relevance. I mean, I understand he may not have read the amendments and certainly doesn't seem to understand the impacts of all the powers being stripped from the minister, but he has to be relevant when we're discussing these amendments, and he is not being relevant at all.
Thank you, Mr. Julian. The problem that I have with this is that they're doing indirectly what they can't do directly, and that is basically contesting the ruling without formally challenging it. But he is speaking to the tenor of the amendment in that and so I really don't think he's that far off the mark on that. So I'm going to let him go, but I appreciate your intervention.
Thank you, Chair. And you know, just because Mr. Julian doesn't like what I'm saying doesn't mean that it's not true, or that he needs to attempt to impugn my character to say that I didn't read it or understand it. I read it and I do understand it, and that's the sad fact for you, Mr. Julian, is that there are folks who want to hold you to account because we do understand the underhanded nature with which you want to gut Bill 368 and
point of order,
drive
Mr. Chair.
the...
Point of order from Mr. Julian.
We have committee procedures. Personal attacks like Dr. Ellis is doing now is simply inappropriate.
Please, if speaking through the chair would dull the impact of a direct insult, then maybe that's the way to go about it, Dr. Ellis. Go ahead.
Well, you know, sometimes the truth hurts, Chair. You know, again, I think listen, what we're talking about here is we're talking about, and I've said this many times, we're talking about a $13 billion industry which has proven itself to be safe, which around the world, the regulations that Canada has with respect to natural health products have been touted as the best in the world. And what we have now, and it's important to listen, we need to be honest here. And when somebody brings forward an amendment that is going to wreck an industry, that to me is open fodder for pointing that out to Canadians who are out there listening, because I know they're listening, because first of all, they told us they're listening, and second, as I mentioned previously, we have received more correspondence on this, on the original bill than any other piece of legislation that we have undertaken in the last 3 years. And if that's not a telltale sign with respect to, A, how impressed Canadians are with respect to the industry and how safe they believe it to be, and B, their desire to have the freedom of choice to say, this is how I want to undertake my own health maintenance and my own health promotion. This is how I want to do it. And sadly, Chair, I'll continue to speak through you if that makes Mr. Julian's feeling hurt any less, that realistically, Canadians, sadly, because of the last 9 years of this NDP Liberal government, do not have access to health care. Over 7 million Canadians do not have access to primary health care.
Again, Mr. Chair, point of order.
The system that we
relevance.
have,
Yes, go ahead. Dr.
Yeah,
Julian.
the relevance of the filibuster. I don't know why he's blocking a conservative bill, but the relevance of what he is saying is simply completely unrelated to a discussion around the amendment.
There is a wide latitude. I mean, when you start talking about access to health care right across the board, the link is tenuous, but it is there. This is health care. This is access. So, go ahead, Dr. Ellis.
Well, again, thank you very much, Chair. And I think that obviously, and I'd like to say I want to apologize for continuing to hit a nerve with Mr. Julian, but that is precisely what needs to be done when Canadians are suffering out there. When Canadians do not have access, 7 million Canadians do not have access to primary health care. And over the last 9 years, what has the NDP Liberal government done about that?
Point
and the
of
answer
order,
is
Mr.
absolutely
Chair.
nothing, that they have done
A
absolutely
filibuster,
nothing
Mr. Julian,
at all.
Yeah.
Mr. Julian, please.
Thank you, Mr. Chair. I had a 16-hour filibuster to stop the Harper regime on the softwood lumber sellout.
I remember it well.
You cannot repeat, and must be relevant at all times. Dr. Ellis is repeating himself, and he's not relevant.
Point of order.
Another point of order from Ms. Goodrich.
Thank you, Mr. Chair. I appreciate that Mr. Julian doesn't like the content of what Dr. Ellis is sharing, but he is very relevant to the bill at hand and the subject at hand, and has not been repeating himself, contrary to what Mr. Julian would like us to believe. And I believe that he's explaining very clearly why so many Canadians actually do rely on natural health products because of their lack of access to a primary health care, and that is part of the crux of the problem we're in. Perhaps this wouldn't have as significant of a blow if every Canadian had access to primary health care, but we know that that is not the case. So that is not a point of order. Thank you, Mr. Chair.
I'm inclined to agree with Ms. Goodrich. Go ahead, Dr. Ellis.
Thank you very much, Chair. Before I was so rudely interrupted, the interesting point here is the fact that we have heard from Canadians on two major points with respect to primary health care. Most importantly, they say that they cannot access, so they must, sadly, in a system of universal accessibility, that sadly they cannot access the system, and therefore they are required, because they must live, to look after their own health needs. And what they have found is that by using natural health products, they are able to promote and maintain the health in which they freely choose to in a country which is based on freedom. I think the other important point here is, once again, Mr. Julian would have us believe that his motion, his wrecking motion, does not have the intent to wreck this bill. We have clearly heard from the person who created the bill that it does, which creates a significant impasse at the current time. And I think it bears explaining as to why this is so incredibly important, especially in light of the fact that I would directly quote the Prime Minister saying back in 2021 that they were going to bring 7,500 doctors, nurses, and nurse practitioners to practice here in this country. And what we do know, which flies in the face of the misinformed Minister of Health, that the access to primary care is getting worse. We heard that testimony here at this committee, actually from the Minister of Health, when questioned on this very topic relating to Bill 368. We heard the minister say very specifically that access to primary care was improving across this country. When, it's not funny but laughable when if you actually go and talk to the Canadians who have the ability to vote, that they know, and I know that in our offices we receive messages every single day from Canadians who say, I can't find a family doctor. I can't find a family doctor. My daughter can't find a family doctor. In fact, I had an email today from a constituent who said, this is an appalling situation. Not only do I, the mother, not have access to a primary care provider, but my daughter, who just had a baby, does not have a primary care provider, nor does the newborn baby have a primary care provider.
That's insane.
And so as we begin to look at the dastardly situation created by the ineptitude and unfortunately clueless attitude that has been demonstrated here over and over again by the Minister of Health, that Canadians have had to turn to looking after themselves because they don't have the support of a primary care physician. And I would go on to say that it's very likely that many of the claims, which again are unsubstantiated by ISMP, could have been simply mitigated by the fact if those individuals were able to speak to a primary care provider. I would also go on to say that I find it interesting that as we resume debate on the motion for that particular group of individuals to bring their data to this forum, to this committee, that once again, I can't understand why, but Mr. Julian had to have his own way defeating the motion, which we could have had 20 more minutes to talk about this bill, but he had to have his own way to move a unanimous consent motion to bring forward the exact same motion that he voted against in the original context as it was brought forward at the last meeting. And to me,
Point of order,
that
Mr.
actually
Chair.
points towards
Mr. Julian
his-
on a point of order?
Of course, the reality is I voted against the filibuster that Dr. Ellis is now performing to block his own bill, or a bill of his Conservative colleagues.
That wasn't a point of order.
Point of order.
Go ahead, Dr. Ellis.
Thanks, Chair. And I think it really quite
Mr. Goodrich, have another point of order?
Yes, and I want to just continue relaying this, Mr. Chair, because the member from the NDP, Mr. Julian, who is an experienced parliamentarian, who has been here far longer, I think I was a staff when he first was here, he's continually using points of order that are very clearly not points of order, and I think that that is a detriment to this conversation that we are having and the debate we are having here.
I ruled that it wasn't a point of order, and what you did just now is the very thing that you accused him of, raise something on a point of order that wasn't a point of order. Back to you, Dr. Ellis.
Thank you much, Chair. And once again, I find it fascinating that for the benefit, again, of Canadians out there watching, it is important to understand why as we call it colloquially here in the Ottawa bubble, a wrecking motion cannot be allowed to continue forward. Now, is this a Conservative proposed bill? Yes, it is a Conservative proposed bill, absolutely. In the original format, which was proposed to say that natural health products cannot be considered a therapeutic product. And what we have seen from Mr. Julian is that clearly he wants natural health products to be considered therapeutic products, which is in, again, direct contravention to the drafter of the bill. So as we look at some of the products that will be affected by this, we had a great testimony by a practitioner of Chinese medicine named Pierre Chen, who was here at the last meeting. And he has a school in Mississauga where he teaches traditional Chinese medicine. He is also a Harvard graduate. His father has been a practitioner of traditional Chinese medicine for decades and provides care to thousands of individuals in the Mississauga area. And as I took the time, and maybe Mr. Julian hasn't taken the time to actually visit businesses who will be directly impacted by this bill. But what I heard when I took the time to go and visit Mr. Chen is that the vast majority of his products, even if the definition of therapeutic product were applied to natural health products, might not make that much of a change in the overall cost of the actual natural health product because they were frequently used, frequently prescribed by traditional medicine, Chinese medicine practitioners. What he did make clear, though, was that there were also a smaller fraction of substances which would be significantly impacted because they were not prescribed or used often, that their cost would go from approximately $30 to $50 for a large size supply to $1,500 for a large size supply. And which that would mean that those folks that have the opportunity to use those products, it would be certainly significantly negative in their ability to pay for those products. As that difficulty continued and the labeling requirements also were then applied to natural health products, what we also know is that the labeling requirements would become unnecessarily burdensome. And indeed, when I liken it to when I went and visited a distribution center for McKesson, one of the largest medication distributors in Canada. I had an opportunity to visit their facility as well. And what you clearly see that when these bottles of medications are picked, these large and floppy accordion-style plastic-laden labels stuck to the side of a bottle by glue, two things will happen. First of all, the accordion-style label will unaccordion itself, if that's it's perhaps not a word, but descriptive of what will happen. It unravels and then becomes floppy and will gum up the machines, of course, because it's not meant to be able to pick a bottle of a product with a long floppy tail of plastic hanging off of it. The other, of course, a very negative thing that will happen is that when it's unraveled, it will come off of the bottle. So not only then do you have a large floppy tail with glue on it flopping around inside a machinery, but then you have the glue there as well, which of course in the vernacular will gum up the system, and everything then comes to a crashing halt. So when you begin to understand the difficulties of adding these large accordion-style plastic labels, that starts to have this downward effect when you require companies to put this labeling on. And I think the other sad thing is that inside the natural health product industry, there is an obvious ability to begin to use novel ways of labeling, such as QR codes. And QR codes, especially in an industry which has a very low likelihood of harm, and I'll come up to the products which are mainly prescribed and used by individuals in Canada soon. But when you have an industry that has a low degree of harm, the obvious move from printed labels with tiny, tiny print, and I know that certainly as I reach a certain age, it becomes more difficult to read that tiny print, that it would make only good sense to say, would this industry be interested in trialing those low-risk medications with QR codes? And what would that enable? Now, there will be people out there who will argue to say, yeah, you know what? Not everybody has a phone to scan a QR code. I understand that. However, that being said, looking at this as an opportunity to begin to trial QR codes, this is a unique opportunity in low-risk environments that would allow those who have the technological ability to scan a QR code, it would allow them to begin to say, hey, what if we were to transition, for instance, ultimately, as an ultimate goal, prescription products to a QR code. Now, again, as many of you know, the Compendium of Pharmaceutical Sciences, the CPS, is a large dictionary-like tome, again with tiny print, that lists all the known side effects, not just those that are those are common or that those are serious of prescription medications. And generally speaking, the CPS is not available to the general public, but often accessed by healthcare professionals. And as you look at it, you know, wouldn't it be interesting to be able to take that amount of information and add it to a QR code and allow people to access it so they could be better informed themselves? And I would suggest that a better informed populace is able to make even better decisions on behalf of themselves and their family members to say what is going to suit their abilities. I think the other huge benefit with QR codes, as we are a varied nation with varied backgrounds and cultural practices and languages, that QR codes would be not only easy to update with respect to the information that is available to the consumer, to the patient, but also with respect to the language in which it were presented. We did hear, whether it's true or not, from the ISMP group, who said that reading labels presented a challenge to people, and that was one of the reasons for a potential adverse event. I don't know, because I don't have that information. It would appear that ISMP doesn't want to provide it until Mr. Julian has attempted to gut Bill 368. But once we receive that information, we will be able to clarify as to whether a language disability or an inability to read English, for instance, or perhaps it was in French, I don't know, because I don't have that data. But that would be interesting to know. Again, if we had the data to make our decisions upon, it would be interesting to know if a new and unique solution on a trial basis was able to take not only English, but any language, and provide it to folks who had the ability to access it, such that practitioners who sold natural health products had that ability to say, hey, you know what, I understand that English is not your first language, but if you were able to yourself scan a QR code or find a family member who is able to scan this for you, if you didn't have that ability yourself, that you could read the indications, the potential side effects, whether they are serious or whether they are minor but frequent, that you could then access those in your native language. And for me, I believe that that would be an incredibly unique and useful situation to be able to look at and again, I will say, an incredibly low-risk segment of the market for Canadians to be able to say, yes, that this is what I would like to see on a moving forward basis. Again, why do we say low risk? Well, we believe it's low risk even though the data is scant, but the data that we have been able to receive in the low risk environment is related to comparisons with other difficult environments such as prescription drugs. And when you look at prescription drugs, what we could understand from the fairly recent data is every single year, approximately 13,000 seniors are admitted to hospital because of prescription drugs. Now, does that mean that we should tighten up the regulations around prescription drugs? That's not what I'm saying here. But what we need is a significant context with respect to natural health products so that we can understand the safety that is associated with natural health products. And when we do understand that 13,000 seniors alone, of course, as we all know, that the definition by Health Canada with this particular study is age 65 and older, that they have been hospitalized due to the side effects of the prescription medications which they are taking. So when we hear this number thrown about of 700 individuals who may have had an adverse effect attributable to a natural health product, without the context, it's impossible to know whether this is a serious adverse event or whether it is simply a problem, and again, I'll go back to what I heard them say with reading the label and they got the product that they didn't want and they couldn't get a refund on it. Now, that's not certainly not serious, and I'm not convinced that it's an adverse event that is related to a natural health product. So that is why it's incredibly important to have the data that we will not have to be able to complete the study on Bill 368 to say there's no reason for Mr. Julian to want to have his NDP 1 amendment, which then moves natural health products back into the realm of being a therapeutic product. So that is what presents the difficulties here. And I think that for Canadians to have that ability to choose what they want, that's an incredibly important part of society here in Canada. And you know, whether or not I understand traditional Chinese medicine or somebody else doesn't understand it, that's okay. I don't need to understand it, but what I do need to understand is it a sector of the Canadian economy and Canadian healthcare that people choose to improve or maintain their own health, and is it safe? And I believe that because of the numbers, even the numbers that we've heard thrown around, and the report that Deloitte was able to do on behalf of the natural health product industry, that we do then believe that this is a very safe sector of the healthcare industry. You know, one of the things that we did here, Chair, as well, is related to vitamin D and vitamin D overdose. Now, again, without the substantiation of that particular case, I find it difficult to believe. Now, why do I find it difficult to believe? It's difficult to believe because many folks would take vitamin D in the dose of 1,000 international units a day, which, again, that happens very, very commonly. But when you look at the science of vitamin D, exposure to sun, if you're out in the sun, and again, this is not me giving advice to get you out in the sun, but just as an important indicator of not having data with respect to this bill, that when you are out there in the sun on a great sunny summer day, that vitamin D, that you could achieve a level dose of 25,000 international units of vitamin D just from the sun alone on a one-day basis. So again, we heard Minister Holland here making, again, an egregious claim without substantiation to say that there was an overdose on vitamin D. Now, Minister Holland is not a healthcare professional. Does he know it was vitamin D from vitamin C or vitamin B1 or B12? I would suggest to you that he probably does not know that. So without the data to substantiate the egregious claim, again, it casts a shadow and a pall over top an entire industry which has been unsubstantiated and unwarranted, which I think directly points to the need to have data to understand the implications of changing any legislation with respect to natural health products. Again, we look at vitamin B12, and you know, back a long time ago when I started to practice medicine in Truro, Nova Scotia, we often injected people with vitamin B12 on a weekly basis. And now what we do know is that for folks who have B12 deficiency, if you take enough of it orally by mouth, that you don't need to come every week for a vitamin B12 injection if you're B12 deficient. And certainly as we began testing folks for B12 deficiency, we also realized that many of them were having supraphysiologic doses of B12 and certainly getting the B12 at the frequency with which it was originally administered was not a requirement. So there are many different vitamins that we know are very safe. Many of them, when you look at the fat-soluble vitamins, for instance, vitamins A, D, E, and K, that is one particular.
Mr. Nakvi.
I've been very patient throughout this meeting, perhaps speaking for the very first time, and I'm enjoying the lecture on vitamins. I'm sure all of us are. But I have lost the relevance to the point, and I'm really debating in my head whether Mr. Ellis is arguing the amendment or challenging your ruling. Can we get a response to that question, please?
Yeah, if I follow the argument is that the amendment has a detrimental effect on the industry, and as if the industry is hurt, access to health care is hurt. The level of detail on vitamins is probably not warranted, but I think the thread of his argument is one that there's a sufficient link that I'm not going to intervene. Go ahead, Dr. Ellis.
Well, thanks very much, Chair. And, certainly I think the difficulty that my colleagues are having is, again, a lack of understanding of the industry. And as we begin to look, as I said, at safety, I think it is important that people have an idea of taking some of these medications, even if they take them, and that's not the idea, but even if they were to take them in inappropriate dosages, that much of the time they are not harmful to folks. And so not having that data for us to be able to see that and to begin to take that data and to parse it out, to look at it closely, and to say, this is a really important event and this is a recurrent event. We did not hear that from our friends at Health Canada, that there were recurrent events with certain substances, because I would suggest to you that they already have that ability to recall. And I think that we heard that here with respect to testimony when the officials were here previously, to say that even when a particular manufacturing facility had some struggles, that when they were given the appropriate guidance, that they actually made the appropriate choices and changed the difficulties they were having. Again, we heard very inflammatory language from the minister attempting to say that there were, and I'll repeat his words exactly, there was a factory full of rat urine and feces. And again, I don't know why my colleagues want to present these disparaging remarks, whether it be Mr. Julian or Minister Holland want to present disparaging remarks with respect to the natural health product industry. I don't know why they would. That for me doesn't really make any sense. But when we know that many of these substances, again, I'll turn back to those, looking at other minerals, whether they be calcium and magnesium, and certainly magnesium is one of those things that we know is a very, very safe mineral as well. People are often and don't realize that they are deficient in magnesium, and they have to take significant and repeated doses of magnesium to attempt to get their levels back to a physiologic amount. When we know, though, that even taking significant amounts of magnesium could cause loose bowel movements. Now, do loose bowel movements, is that a side effect of magnesium because we are attempting to give you significant amounts to boost your levels? That makes it very, very difficult. But again, we don't know that because we don't know what the data is. And if we would have had that data beforehand, I might be more inclined to say, one or other of these amendments makes perfect sense or it doesn't. So again, are they side effects and known? And again, if we had the ability to understand what the data said, then that would give us a much more fulsome discussion. I think the other thing that we heard about a lot here in this committee is related to nicotine-containing products. And I find it fascinating that this committee is now in a grave hurry without enough data to push this Bill 368 forward. Then we also know that what we also heard in the exact contrary opinion was with respect to nicotine-containing products. And what we heard from officials who sat over there was that this NDP Liberal government cannot enact legislation quick enough to keep up with the changes in nicotine-containing products. And we also know that the sloppy nature with respect to how nicotine pouches were delivered to this country, and how Health Canada officials, in collusion with Minister of Health #1, was unable to actually prevent this product from coming to Canadian shores. And then what we heard when we suggested that legislation should be drafted specifically to deal with nicotine Canadian products, that the sloppy nature of the Health Minister #2 to try to clean up the mess of Health Minister #1, that they were unable to do that in a timely fashion to be able to keep up with the industry. Now, as we begin to look at nicotine-containing products, the other difficulty is related to contraband cigarettes. And, you know, these are obviously manufactured in a factory as well. And the question then would remain is why is CFIA not out there inspecting those factories and getting contraband cigarettes out of the mouths and hands of Canadians? So I find it fascinating that we are required to fast-track Bill 368 at the behest of Mr. Julian, and that this is taking too much of his time. However, that there is an impossibility with the NDP Liberal coalition to create legislation with respect to nicotine-containing products. And what we do know, though, is that there is more and more youths turning to vapes and flavored vapes, which they are actually purchasing online, and which is something that a future government a future Conservative government must actually tackle. We also know that they do not have the ability to look at nicotine-containing products such as nicotine pouches. And how does that actually fit into the legislation? Now, when we look at the nicotine-containing pouches, I find it distressing because they were actually brought in under the Natural Health Product Regulation, which directly relates to them being a smoking cessation aid. Now, I hope that all of my colleagues did their background, and I suspect Dr. Pawlowski and perhaps Dr. Hanley did, not to be disparaging to others. But when you look at nicotine pouches as a smoking cessation aid, the likelihood of having evidence to support them as a smoking cessation aid is almost zero. There have been no studies done. There's no ability to say how much milligrams of nicotine in a pouch is equivalent to X number of cigarettes or X amount of nicotine in a vape-containing product. And then how long would you stay at a certain milligram of nicotine, and then move down to the next lower amount of nicotine? Those studies do not exist. Now, sadly, on behalf of Canadians, that is exactly how Minister #2, also known as Holland, decided to deal with nicotine pouches, is to say that these are a smoking cessation aid, and with much fanfare and bombast and foolishness, said that they must only be sold in pharmacies because they're a smoking cessation aid. Now, the problem, of course, with that is there is absolutely no evidence to say that these are a smoking cessation aid, and there's no pathway forward for pharmacists to be able to prescribe or guide prospective patients to use nicotine pouches to get off of smoking. So if that doesn't exist, and these are only being sold in pharmacies, the difficulty then is that pharmacists have not developed that ability to identify and ID folks who may be underage and purchasing these products. And as we start to look at that, where does some of that expertise exist? Well, I find it absolutely fascinating that nicotine-containing pouches are sold, and again, I'm not meant to be disparaging to my pharmacist colleagues, but they are sold in an environment which does not have expertise in IDing folks, but they are not being sold in an environment also known as a convenience store, which has the ability to ID folks. They have a long history, and whether we all like it or not around this table, convenience stores are the place that do sell cigarettes and other nicotine-containing and tobacco-containing products, and in some instances they also sell alcohol, which is precisely why I would suggest that when we look at regulations with respect to nicotine-containing products, that convenience stores may be a very reasonable place to sell nicotine pouches, since the regulations that were brought forward by Health Minister number 2 are wholly untrue and inadequate to deal with nicotine-containing products such as pouches. So as we sit here in committee and say that we should push forward without the data, which would make us a much better informed committee on behalf of Canadians with respect to natural health products, because I think it is a shame that those around this table from the NDP and Liberals have allowed shade to be cast upon an incredible industry employing thousands of Canadians to the tune of $13 billion. So as we begin to look at that and understand the economic consequences, Joel Tuna was another great witness who was here, who has been in this business, and I believe, colleagues, correct me if I'm wrong, but he has been in the natural health product business for more than 50 years. He is also a proponent of teaching others how to grow natural health products, and I can't remember exactly, perhaps herbs like oregano and other spices, of how some folks may believe that that helps maintain your health. But he also made it very clear that he is not just a proponent of the industry, but he's a resource within the industry, that he will take on newcomers to the industry so that they understand what good manufacturing practices are, where to look inside Canada for growers who have the ability to produce substances that Canadians want to use that don't have contaminants in them, and that he presented a very collegial attitude that exists inside the natural health product industry. He has, of course, as I said, been in this country doing this business for 50 years, and I think that that would certainly qualify him as an expert. I would also go on to say that he made it clear that recommitting natural health products to therapeutic products, that the difficulty that proposes to folks in this industry, in the sense that those businesses would be forced to move all of their business ventures mostly to United States. And then as we start to look at the anti-business environment that the NDP Liberal government has created, we also know that many business interests have already moved south of the border, and that investment in Canadian industry has gone down, and it's creating a significant problem with respect to Canada's GDP. We also look at the unfortunate case of the Canadian dollar, which sits now at less than 70 cents. And that creates a difficulty as well. So one of the other things I think that it would be important, a question that I would have to ask, and perhaps, Chair, I might pause for a second to understand, obviously it's Thursday, there are folks who don't live here, but if there are folks who have flights and they would like to consider an adjournment, I'm okay with that. But if not, I'm quite happy to continue. I'm trying to be collegial, and if you would allow me not to cede the floor, but to simply ask that question, I'd be quite happy to do that, sir.
I'd be quite happy to do that, too. Is it the will of the committee to adjourn the meeting? Heads nodding all around. The meeting's adjourned.